Today's topic: what exactly is community property? There are a number of states, including Nevada, that are called community property states. So what is community property? Simply put, in a divorce or separation, community property is all of your assets and debts that you acquired during the marriage, or that have increased in value during the marriage. Now, when we say property, we're not just talking about a house, although that's typically the largest asset a couple has. Property is also cars, boats, trains, planes, automobiles. It's stocks and bonds and pension plans and IRAs and 401ks, military retirement benefits. It's your household furniture and your dogs. Any property which a person has prior to their marriage is considered sole and separate property in most cases, unless they commingle the asset or they use community funds to upkeep the asset. For example, let's say you own a home. You purchased it, you paid $50,000 on a down payment. 3 years later, you get married. You're married for 10 years. Your spouse works. You have a joint bank account that all of your money goes to, including your spouse's paycheck. And you take out a second mortgage 5 years into the marriage to make home improvements, and your spouse is listed on the second mortgage. Even if your spouse is not on the deed for your home, it's likely that in a divorce or settlement, you're going to have some community property issues regarding that house, because you've commingled your funds in a joint bank account, and you've used your spouse's credit with the second mortgage to make repairs and upkeep on the property. If, on the other hand, you pay all the bills yourself for the home, you make the mortgage payment, the utility payments, they all come from your income. Your wife or your husband does not work, they stay at home. Or they do work, but they keep their money separate in a separate bank account. And none of that money is used to keep your house up. In such a case, it's likely that you're going to be able to keep the home. However, in many cases, a stay-at-home spouse has a claim to at least the increase in value of the house from the date of marriage to the date of the divorce or separation, because they've stayed home, maintained the household, maybe raised the children, and so they're going to be entitled to a portion of that asset because you would not have been able to work and hence better your career and make money without their help. In a nutshell, you should always assume that property you own during marriage is community property. The only sure way to avoid such a problem is to not commingle assets, not use joint funds for upkeep of the assets, and preferably have a validly executed prenuptial or postnuptial agreement. Prenuptial and postnuptial agreements are simply a contract where you decide upon signing this contract, this is how we're going to split our assets. This is how we're going to split our debts. It's a way to avoid having to fight at the end of a relationship. You get to make all these decisions while you still get along. Either way, you should consult with a licensed attorney in your state, as family law issues vary widely from state to state. I'm John Cereso with the Nevada Law Group. If you have questions or would like to comment on this topic, feel free to visit our website, www.nevadalawgroup.com. This has been The Legal Minute.